be sure to have your cell phone on silence. All right. Hear ye, hear ye. The Court of Appeals for the First Session. Pursuant to a joint United States Constitution and the Honorable Court.
Good afternoon. Please be seated. Welcome to the First Court of Appeals. Today we sit here in a panel. I'm panel chief Justice Amy Guerra. We have Justice David Gunn and Justice Susana Docupil on the panel. And we have two cases on the docket this afternoon. The first one is case number 0123000638 CV. Is it Chiv? I'm not sure if I pronounced that right, versus Figueroa. And the second one is 0125000055 CV, Houston Methodist St. John Hospital versus Cagle. And we're going to hear Chiv versus Figueroa first, and then we'll take a slight recess, and then we'll come back and do the second case. So starting with Chiv versus Figueroa, could we please have counsel make their announcements?
Sarah Allen on behalf of Appellant Brandon Chiv.
Andrew Garman on behalf of Mr. Figueroa.
Thank you. Each side will have 20 minutes for argument, and I understand appellant has reserved 5 minutes for rebuttal. Is that correct?
Correct, Your Honor. Thank you.
Great. Before we begin, I'm sure you're familiar with the lights that we have on the clock. As you know, the green light means continue, yellow light means you have 2 minutes remaining, and red light means stop. However, if you are in the middle of answering a question from the panel, feel free to continue, and we will make sure to even out the time to the extent there is any additional time given to one side or the other. And with that said, we are now ready to hear from counsel for the appellant.
May it please the court. This court should reverse the portions of the jury's verdict in this case that were not supported by legally sufficient evidence, consistent with this court's prior precedent in the Lara versus Bowie case, which, Justice Guerra, is your own opinion. In this appeal, Chiv challenged the following portions of the jury's verdict. First, $40,001 in past medical expenses for medical care for the diagnosis and treatment of injuries that are not common or basic. These specific injuries in this case were disc herniations and cervical and lumbar radiculopathy.
Now wait, if that's true, which part of the verdict? Because 40,000, the jury found 57,000.
That's correct.
Past medical.
We did not challenge the initial treatment with the chiropractor before the diagnosis, or the initial assessment by the treating physician, who then referred Mr. Figueroa on to the pain management specialist. Consistent with the case law that holds that there are some types of immediate post-accident treatment that lay testimony may be sufficient to support. So in this case, we focused our challenge on the diagnosis and treatment of the injuries that this court has held over and over again require expert medical testimony in support of causation.
And if you're right about that and the 40 goes poof, then what?
It would be a reversal of that portion of the verdict. And what we, in our briefing, Your Honors, what we did is we raised the legal sufficiency challenges initially, And we have alternative arguments regarding other errors at trial that might possibly result in a new trial. But the primary thrust of our argument is that the portions of the award for which there's legally sufficient evidence should simply be reversed, and a judgment consistent with those reversals affirming the other portions of the verdict would be entered, which is what the court did in the Lara versus Bowie matter.
So if the 40 goes away from the 57, that leaves 57 minus the 40.
Correct.
Which could be affirmed.
We haven't challenged it.
I understand. Okay, thank you.
Of course. And so there is no dispute in this case about whether or not there was expert testimony provided. There was no medical expert who testified at trial.
Would you need an expert if he said, look, I got really beat up, I got bruised and had swelling, and that's it?
And I don't believe so, and it depends, of course, on what the damages being sought are, right? In this instance, with the past medicals, the damages being sought are specifically tied to, and the court can look and mathematically figure out exactly what treatment was provided for what types of injuries. And so that's, I believe, a distinction that is easily made in this case, and that the court has done in the past as well. With regard to the $50,000 in future physical pain, the reason that we have raised a challenge here is that through the evidence and argument presented at trial, Figueroa tied his pain, ongoing pain in the future, directly to the diagnosed disc herniations and diagnosis of radiculopathy. We see that through the medical records that were presented at trial. The last date of treatment was September 2019, several years prior to the trial at issue in this case. And the final diagnosis was that of lumbar disc displacement with radiculopathy, as well as cervical disc displacement with radiculopathy. I mean,
why does that matter to pain? I mean, plaintiff says, I got rear-ended, I'm hurting. Why do we care about anything else?
Well, because the evidence at trial demonstrates, and it was not just his testimony. There's testimony that I can point to where he said, my pain wasn't resolving, so I went to the pain management specialist, and they finally told me my pain was because of my disc herniations and my radiculopathy. And they said, you need to get injections to treat those diagnoses, and that will reduce your pain. We can directly tie the claim for pain to the diagnosed injury for which there's legally insufficient evidence of causation. And I would like to direct your attention to a case that was just recently last week issued. We have not obviously briefed it. It is from the Ninth Court of Appeals, but it is an opinion titled Valier versus Holloway, and I can give you the Lexis citation. It's not even in Westlaw yet.
If it's last week, it'll be on Thursday. We can find it.
Okay.
Because Beaumont hands down cases every Thursday.
So in this case, Valier versus Holloway, the plaintiff did not seek any past medical expenses or future medical expenses. Instead, they submitted the case on the general damages only, including physical pain and impairment. The plaintiff at that case brought a nurse practitioner to trial to testify over the objection of the defendant, who said that the nurse practitioner was not qualified. The Ninth Court of Appeals agreed, determined that the nurse practitioner was not qualified to opine on the causation of the diagnosed disc herniation injuries. In the absence of the and in that case also, it was clear that the arguments and the testimony of the plaintiff at trial were that the pain and the impairment was tied to the diagnosed disc herniations. Said, I got this herniation, I'm going to live with it for the rest of my life, and that's what we're asking. That's what we're asking you to compensate the plaintiff for. When you have that direct link between the damages sought and the diagnosis, and it's not a common or basic diagnosis, you have to have that qualified expert testimony. And so the Ninth Court of Appeals...
What if there'd been no expert at all? Plaintiff, only witness, like here. Plaintiff gets on and says, look, I was fine before the wreck, I got smashed up, now I hurt like I'll get out. I don't understand if we just ignore the expert, why that's not enough.
Well, and what I believe happens in these cases is that the records are brought in for a specific purpose, which is to tell the jury, we're not just dealing with bumps and bruises and scrapes.
But I'm talking about pain. I'm not talking about a diagnosis, whether he's got any condition at all. Just if he testifies, I hurt a lot after that incident.
Right.
Why can't a jury infer, okay, your pain started right after you got hit? What's wrong with that?
It's possible. I think what we have here is a situation where, you know, the accident happened years before trial, and there's a certain amount, and again, in this case, we didn't challenge the award of past pain. Specifically for that reason, Your Honor, is that what we're dealing with is a situation where the pain and the ongoing pain in the future is something that if he said, I'm still in pain, but never brought up the diagnosis of herniations, never used these scary words that juries hear and are concerned about, never argued, like counsel did in opening argument in this case, disc herniations are very painful, right? There's a direct link in the way the case is presented. And when that is the case, and when the attempt to increase the general damages awards are based on a repeated claim of non-common, complicated physical injury, then in order for any awards that are based on that injury to stand, you have to have legally sufficient evidence of causation of the injury. Now, and we can't look at this record and say that the jury only awarded it based on his testimony of pain and not based on the diagnosis, because that evidence is all in there and it's intermingled.
Well, yeah, and that's where I'm getting at. In a sufficiency attack, I mean, we do that all the time. We say, look, is there sufficient evidence? Maybe there was extra evidence that nobody should have heard, but they heard it, so let's just ignore it. If it would be sufficient without the extra evidence about diagnosis, I don't understand why it's insufficient just because the trial had a little bit more evidence.
Well, I believe in this case the reason that is because the specific diagnosis going forward, which is why there's, I think, a distinction between the award of past damages and future damages. We are 4 years post-accident at this point. The pain that is, the experience that he's gone back to for treatment and for injections is noted both in the records and through his testimony as pain caused by the diagnosed injuries. And again, I believe that that is an important point. I probably sound like a broken record, but it's that future pain that was testified to. When you look at this testimony, he says, I got the injections, they gave me some relief, the symptoms came back, it's still my neck and my back, which is where the diagnosed disc herniations are. The records themselves indicate that the steroid injections were prescribed specifically to address the disc herniations and radiculopathy. So we can see that the existence of any ongoing or potential future pain is directly tied to these diagnosed injuries and not just to general pain that you would experience in the immediate aftermath of an accident.
I have a question about the state of the record. This deals more with the counter affidavits point, if that's all right. And it may not be something that either side can answer right on the moment, in the moment right now, but I can't tell. The way I see it, volume 5 of the reporter's record has, at least supposedly has exhibits. But I'm having difficulty figuring out what exhibit is what.
I understand, and I can tell you why that happened. When this, for some reason, when we ordered the clerk's or the reporter's record, the court reporter at trial could not find the exhibits that were presented at trial. We worked together with counsel to recreate those exhibits and submit them. They were then uploaded without exhibit stickers that were present in the original trial exhibits. We actually have a letter that we filed with the court that might provide some additional clarity.
That would be helpful if the two of you could give us what you think are the actual copies of the exhibits.
Absolutely. And we presented some of that information on what was going on in August of 24, but I would happily afterwards meet, confer, and agree on where those pages stop and start.
I suspect it's not controversial. Probably,
I don't believe it is.
Probably everybody knows everybody on your side knows what the exhibits were. It's just not clear to us. And so I'll just lay out where I'm coming from on this. In the counter affidavits argument, I'm inclined to think, subject to argument, I'm inclined to think you have the better of the argument that the counter affidavits should have been struck. But I have a question about harm. Suppose you're right, that Judge erred in striking the counter affidavits, then what? Because I'm having trouble finding, okay, why does it matter? I see rulings on the record that admitted a bunch of medical records, a bunch of maybe the billing records, I'm not sure exactly what they are, essentially without objection. And so I'm thinking, okay, well then why do I care? So talk me through the harm.
Okay, well, and I believe that the error was preserved in the response to the motion to strike the counter affidavit, because the argument there is, look.
Yes, it's preserved, I get it, but I don't understand the harm.
Sure, so if the counter affidavit is not struck, the 18001 affidavits that accompany the medical billing records are not sufficient to establish reasonableness or necessity under the Civil Practice and Remedies Code. Therefore,
yes,
a medical provider would have had to come to testify.
Well, not necessarily. You could have papers. You could introduce the same documents, and if your side doesn't object, then they come in without objection, and there they are.
Well, I mean, I believe that typically that would not be considered. It's possible that could have happened without objection. I believe that the arguments made at the pretrial regarding this were focused around the fact that if the affidavit doesn't come in, then a provider has to come and testify to that, and we would get the opportunity to cross-examine the provider.
A provider has to do that, but if the plaintiff introduces grossly inadmissible documents and you don't object, then it has probative value.
Well, and in that circumstance, I believe there would be no evidence of the reasonableness or necessity of the medical bills. And I believe that is something that has to be proven by somebody who's qualified to testify about whether or not the treatment was reasonable in price or necessary as a result of the injury. Those are not the types of things, I believe, that the plaintiff themselves could testify to, absent some unique qualification that one plaintiff has that nobody else in
Sure.
these cases
So I
do.
guess of these exhibits that you're going to help us with, do those exhibits get there? Assume, if those exhibits came in with no objection, which I'm asking you only to assume for the question, not to concede. If they came in, because I saw people talking about, hey, the affidavits don't go back, but these records are going to be admitted, okay, fine. Do those documents contain evidence that would support the verdict?
Not of reasonableness or necessity, not standing alone. A medical bill standing on its own does not say anything about.
There's not an opinion. You're saying there's not somebody in those records.
Not that I've seen. And typically,
Fair
the medical bills are just going to list, the treatment codes and the amounts.
Dollar
and
amount,
the
but
dates.
not an endorsement that the dollar amount is a proper
There's
amount.
typically not a narrative that associates, that deals with the reasonable necessity. That's exactly what the 18001 under the Civil Practice and Remedies Codes is intended to do. And so the harm analysis is that in the absence of the counter affidavit, what was evidence that would not support reasonableness and necessity is immediately converted into sufficient evidence
sufficiency problem
of reasonableness and necessity.
Got it.
Yes. The final award that we have challenged is the past mental anguish damage. I didn't see anything in the briefing in response to that. I believe even the trial court recognized before they were, when they were discussing the submission of the question to the jury, the trial judge herself said, I don't think there was sufficient evidence of mental anguish, but I'm going to let the question go forward. I believe in your review of the record, you'll agree that there's just insufficient evidence, especially under the new standard of the Gregory versus Shohan case out of the Texas Supreme Court, which requires not only the existence of the evidence of the existence of a mental anguish injury that is legally cognizable, recognizable, as well as the evidence that indicates the nature, duration, severity, and reasonably ties the award to the evidence presented at trial. I believe that is also missing. Those three elements of the jury's verdict can be reversed and rendered, and the alternative arguments, and if that is the court's determination, I don't believe that the alternative arguments regarding the counter affidavit or the deposition transcript need to be reached.
Thank you. So, I have a couple minutes extra.
Yeah, I apologize. Thank you.
May it please the court.
make sure we get the clock. I think it's 22.
I see.
I'll do 22, at least 22 minutes.
So I will stop at,
That's fine. Did you just, I'm giving you the benefit of the 30 seconds just to make it a whole number so that we're good. I apologize for the interruption.
no, that's fine. I was just eager to start, that's all. I don't know if I can help you as far as the placement of all the exhibits and such. I do know there was a supplemental clerk's record, which the defendant brought in, and I don't know if it was integrated or cross-referenced in any way with the original clerk's record. One of the reasons this case has been here for so long is because there were issues involving bringing forward the clerk's and the reporter's record. But that's all background, neither here nor there. I do want to start with Justice Gunn's question about, the whole issue as to what about the counter affidavits, should they have been struck? To their credit, defendants are amazingly blunt about this. We weren't going to hire an expert. We were going to we're going to make defendants hire an expert, or plaintiffs hire an expert, so that we could poke holes in this theory based on his expert, right? I do not think 18001 in any version, and oh, by the way, this is the pre-2019 version governs this case because it was filed in March of 2019. I don't think any iteration of that case, of that statute, had that in mind. In fact, as I read it and I recall, 18001 is supposed to cut the costs of litigation and personal injury actions for everybody. It's not supposed to unfairly apportion litigation costs on somebody else. And which is why it's written so that it assumes that everybody's going to bring, if you're going to contravene this streamlined method, then we are going to make you contest it, actually contest it by telling us what you're going to contest with your own expert. And this is kind of unwritten, but it's also strongly implied that you don't get to force the other side into these costs if you're not actually going to play ball the way the statute sees it. And so I think that that's just not the intent of the statute. That's not the intent of the legislature in any iteration of the statute.
So is it your position that the trial court could and should have, as in this case, struck the counter affidavit because they didn't designate an expert?
I think that if they, as I recall, the trial court bent over backwards to get them to bring an expert, but they had not designated an expert. And they said after recess overnight, they said, we're not bringing an expert. And at that point, she struck them.
So is it your position that that was proper?
I believe it was proper. I believe that we're not supposed to play games with this statute. It's here for a purpose, and the purpose is not that which defendants confess to, basically, as far as make you spend the money, and we'll just sit back and poke holes at things.
What's your best case authority for the proposition that defendants needed to have an expert?
Well, I think that I did not brief that one extensively, Your Honor. And I would have to search, I would refer you to my brief. I'm a better writer than I am an oral advocate. And I hope it's not obvious as I stand here today, but I will tell you that in my reading of the plain language of the statute at the time and now supports that construction. And it is simply that this is to streamline this chore, which, I don't know that there's all that many times when you have a real issue with whether these bills are authentic or whether they're wildly inflated. I think the statute helps to keep that in check.
Well,
And
but
come
those
on,
are
it's-
two different things, right? You said whether they're authenticated is one thing, and whether they're
Mhm.
inflated is whether they're reasonable and necessary. So I assume the records were properly authenticated as business records, but that's not the issue here. It's about the reasonableness and necessity of the charges. Is that right?
Well, reasonableness in my mind does go to whether the charges are in line with, all of the INRI, K&L auto crushers factors are involved in whether it's reasonable, whether we have a yardstick by which we can measure the way these charges are lined out here. I'm sure there are providers who see a litigation case and inflate their bills, but I don't think that this is the case here.
Yeah, that may be right. I guess my concern about your reading of the statute is they could designate an expert, maybe even bring them to the courthouse, but they don't have to put them on the stand. And after they're finished with your expert, they could say, well, heck, the jury's heard enough. I did what I wanted on cross, and I don't have to call them, and so then we're right back.
Well, I'm not going to disagree with you. However, the follow-through of bringing him to the courthouse, for example, of designating him, of retaining him, and at least briefing him on these issues, that shows the intent of the statute, which is to keep people, we are not going to let you run wild with this streamlined method. At the same time, we are not going to, allow you to game it. And I think we're talking about gaming the statute when we're talking about these issues.
Well, then let me ask you a different dimension, which is one I
Sure.
raised with counsel on the other side, which is about harm. Because to me, it probably doesn't matter if the records support your verdict. So but I can't tell exactly what the records are, and like we've talked about. And I know that the two of you can get to the bottom of that and help us
Sure.
reconstruct what are the exhibits, where's exhibit 1, 2, and so on. Because those records largely came in without objection. So I'm willing to give them effect for whatever they say. But tell me, do they support the verdict? Or do you not have what you need to show reasonable and necessary to support the dollars?
Well, I believe that they do, absolutely. The amounts awarded for medical expenses by the jury are consistent with what the invoices and the medical records show as far as amounts, which is, the yardstick I'm going to use as a shorthand for, support in the evidence.
And were your clients' were the affidavits introduced into evidence, as was mentioned? It wasn't clear in this case.
I'm sorry.
That we see the medical records,
Yes, ma'am.
but where is the affidavit that was supposed to support the reasonableness and necessity of those charges? Did it come into evidence? Was it admitted?
I do not believe that. If I am following your question, I know there was an objection to those affidavits going into the jury room. And I believe that the court compelled plaintiff's counsel to tear those off before they were entered into evidence.
Okay.
Well, but were they introduced into evidence during the trial? I understand they were removed before
Sure.
they went into the jury room, but were they admitted during the trial?
I believe that was a condition precedent to their admission. And this was all done, as with many trials, at the very beginning, on the first day when we're talking about housekeeping measures, right? Do you have any objections to your to what's at issue here?
So you believe that they came in as unopposed exhibits, or?
I think that with that, I believe with that precondition, at defendant's request, that those affidavits be removed, it was unopposed. If that answers your question, in other words, they were admitted without objection once that had been taken care of.
Sorry,
Okay.
and I want to get down to the bottom of this. The affidavit that was supposed to say that the medical bills that were attached to the affidavit were reasonable and necessary. I understand that the bills went into the jury room. I'm asking, did the affidavit that was supposed to support the reasonableness and necessity of those charges admitted at trial?
Your Honor, as I stand here, I don't know the answer to that question. I did not dice it up that fine, and so I would have to, if I would be able to submit some kind of letter brief or something clarifying that issue with your leave, I would prefer to address it that way.
That would be helpful as we get our hands on what was the state of the record. I mean, I'm looking at volume 3 of the reporter's record at page 174, where the court says 1 through 14 will be admitted.
Right.
Obviously, you're going to take those affidavits off the ones that you've agreed to take it off of.
Right.
And so that's where you find the discussion. And so I'm thinking, all right, affidavits are out. Somebody show me what got in so we can figure out, is there evidence to uphold the dollars awarded by the jury? So you don't have to do it here, but that would be helpful to us as y'all get together on the record.
I did not examine the record with an eye towards that question. I'll put it to you that way. Very quickly, while my time runs short here, I'm just going to mention that as far as the substance of those issues, I think that some of the Court of Appeals opinions that are relied on by the defendant to, in an attempt to pour out our client, almost all of them, there's only one exception to this, there is lurking in the background another potential cause for the medical bills in which we are trying to hang on, the defendant and recover from the defendant. Of course, Guevara versus Ferrer is replete with that whole issue, and Justice Gunn, I think you were involved in
JLG trucking.
Yeah, I was going to say MJM. It's in my head for some reason, but
it's a great moment in lawyering historically.
But I mean, that involved whether the prior injury was relevant to the issue of damages, and then the court said yes, it is. But then we don't have that here. There's not anything in evidence that the defense can point to as having caused all of these issues and all these medical bills. There was testimony that he was healthy before, and of course he suffered in pain immediately after the accident, and went, I think it was, the accident was just before Labor Day, and the day after Labor Day he went to be treated. But I am, there is no alternative explanation that cries out for someone to segregate this damage happening because of that, and because it might have happened because of this. We need someone to draw the lines between those two and explain to us, or explain to the jury and to guide the jury as to whether these are compensable.
And I have a question about the pain issue, because that was the other topic that we spent some time on it. If you don't mind, why don't we go through that a little bit, because I'm seeing plaintiff take the stand, testify to pain. It seems to be connected to the accident, at least in his version of events, and sort of based on the timeline. Appellant said, well, but you have all of this additional evidence about linkage to particular diagnoses, right? I can't even pronounce the different disorders.
Reticular something.
That's the one, and saying, that puts a cloud over the plaintiff's evidence. That I'm giving you the shorthand. So talk me through your best evidence of the award for future pain, for $50,000 in future pain, based on what your plaintiff said.
I am going to refer to, I'm going to refer to the past experience, which is something that, something you base future damages on previous experience. And in this case, he says that I had to go get this shot, right? Epidural steroid injections. And it worked for a while. And then after a while, I had to go and get another one. And this is in the, I think this is a 2017 case. So this is like in the 8 years he's had 2 shots. And so they are talking about future pain and medical expenses. And I think that the jury took those costs and maybe put in a little inflation something or other and said, well, he might need 2 more of those. Best I can do. But it's not pulled out, I don't think it's pulled out of thin air. There is a lot of testimony about the pain he suffered. And quite frankly, there's just not a whole lot of anything that casts it apart from, you know, the legal status of, you know, proof of the linkage. There's just not a lot of anything else involving the pain he was suffering and the injuries that occurred. This has had plaintiff testifying, and it had defendant testifying. And that's what the record shows. And so, based on the fact that there are no circumstances casting, you know, I'm trying to think of the language from Rule 166AC, where the interested witness rule about clear, positive, direct, and could, you know, not inconsistent with the facts as known, or something to that effect. I think his testimony is consistent with the facts as known. And on that basis, I would ask the court to affirm the award in its entirety. If there are any other questions.
So I don't think you addressed in your brief the issue of past mental anguish. Was that a concession on your side's part?
Past mental anguish?
Yes.
That was the, I believe, the $5,000.
Yes.
I mean, these are damages, and I may have run out of time on that particular point.
So it wasn't an intentional omission?
I was not intending to concede that there was no evidence thereof. If I was going to make that concession, I would announce it to the world, because I don't believe in leaving people hanging or wondering, because that doesn't seem like a professional thing to do. And so that wasn't intended to be a concession. But I didn't have a lot to say about it at the same time. So.
I do have a question about the use of the deposition during Mr. Figueroa's testimony.
Yes.
Do you want to talk about that, or do you want me to just ask my question?
The fact that there was no, the defendant didn't have a Spanish translation of that deposition available for cross-examination.
Yes.
And I think, as I recall, the point he was trying to make is 3 years ago you didn't remember the day on which this accident happened, although you were, you know, although you're saying it was a big deal 3 years ago, you didn't remember what day this occurred, which strikes me as borderline badgering of the witness. And I take the judge's ruling, I think, it would have been different if it had been as truly material-ish. I like to think that. But if you've ever, I have seen in my job duties what it's like when you have someone testifying through an interpreter who's being attacked based on something they said, based on basically a mistranslation, or not a mistranslation, but an error, or, you know, something in translation, and everybody gets frustrated because it's just at that moment really, really hard to figure out where the hang-up is. But there is a hang-up, and it really just gets, it's hard to read, and it's hard to you know, see everybody getting frustrated, and it's hard to derive any kind of, you know, information about the merits of the case from the fact that there's a problem with that translation, or the way it's being translated at that moment, and especially in front of a jury. I think that is something that the court was trying to avoid, and I think that was part of that as well.
Well, you argue in your brief, or you argue generally that because no offer of proof was made, that issue was waived, and of course there's an exception that no offer of proof is required if the testimony was apparent from the context. And so is it your position that because you just recounted what the situation was and the recollection about when the accident had happened and not remembering it, so I guess it's your position that wasn't apparent from the context.
Well, I have to be honest, I'm not sure what would have transpired after that, which is the point of the offer of proof. If they were going somewhere with that, I don't know what that was going to be, and consequently this court doesn't really know what that was going to be. And I don't know how you make a judgment as to any error or harm that would have transpired from that limitation. That's what I can tell you. I do think that was. I think that my interpretation is that the court didn't see a lot of point in going down this road because it was clearly an impeachment type inquiry. I guess that is my answer. It was impeachment, not necessarily to bring out some kind of information that would be germane to the merits of the case. And I don't, and this is another thing I did not investigate as to whether, I know there's translators and I know there's interpreters and I know there's a difference. I have not ever run across a situation in which involving that kind of an issue. I think we're going to run into it more and more as the years go by. But I did not have a chance to investigate whether that is something that's well recognized and well understood. And so I would have to tell you that the court was limiting, I think the court was limiting impeachment test inquiries, and given the other problems that presented themselves, if allowing that to go forward. And I think I cited Rule 611 in there for the rules of evidence about the court has power to limit a line of questioning that might embarrass or otherwise cause a difficulty for the witness. And I think that's the best explanation from my standpoint, or from as I can tell. So that's what I think. So if there are any other questions, I appreciate the court having us down here and asking the court to affirm the judgment as empty.
Thank you.
Thank you, Your Honors. A few response points I'd like to make very quickly is I do believe I heard during the discussion of the best evidence of future pain that there was a suggestion that the jury may have thought that Mr. Figueroa might need future injections and that might form an evidentiary basis for the award of future pain, which I believe would be entirely improper, not only because there never was competent expert testimony to support the causation of the need for those injections, nor was there any suggestion in any of the records or testimony from a medical expert that there would be a need for future injections. And
counsel, how do you respond to the opposing counsel's point that the cases from our precedent that say that certain diagnoses, as we have here with back pain, require an expert, and he's trying to distinguish them by saying, well, there's more than one cause. How do you respond?
Perfect, that was my next point.
Okay.
Basically, I went back as we were sitting here and I looked at the opinion in the Lara v. Bowie case. I know that case involved a young man as the plaintiff. There was nothing that I saw on the record that suggested that there were any pre-existing injuries, or that at trial, the theory at trial, the defensive strategy was to pin causation on any pre-existing injuries. I can't say that I've memorized that record, but it's not in the opinion. And so it can't have been a key part of the holding of the Lara v. Bowie matter if it's not mentioned in the opinion. At least that's the way that I read the opinion. Whether or not it was some issue in some of those cases, the fact of the matter is the rule that's been announced by this court, the 14th Courts of Appeals, the 9th Court, and probably at least most of the rest of the Courts of Appeals across the state, is that there are certain injuries that are just not common and basic, and because of the nature of the injury, regardless if there's some pre-existing cause that the defensive strategy is attempting to point to, the nature of the injury itself is what dictates the need for expert testimony. And I would point out that the Lara v. Bowie case, the Texas Supreme Court denied the petition for review on that matter. So I think that is a key endorsement of the holding of that case that indicates that that rule is straightforward, and it's the rule, and it's not contingent on an exhaustive review of prior medical history or anything like that. It's the nature of the injury itself that dictates the need for this expert opinion and testimony. I do also wanted to mention briefly with regard to the counter affidavit issue. The Texas Supreme Court has instructed us in the In Re Allstate Indemnity Company matter, which we briefed in our motion or in our briefing. They say Section 18001 does not charge trial courts with determining the admissibility of an affiant's opinions, and a trial court's doubts about admissibility are not a proper basis for striking a Section 18001 counter affidavit. I think that goes straight to the heart of what what opposing counsel was discussing in his argument, which is that this is, it's not a matter of what the type of bills are, whether or not you bring an expert to testify at trial. The fact of the matter is that it is a statutory mechanism that says, if you do this, file your affidavit, then that gives you a presumption of sufficiency of the evidence for reasonableness and necessity. If a counter affidavit that complies with the rule is filed, that presumption is wiped out, and you go forward with a trial as you would in any case where the plaintiff bears the burden of bringing forth evidence in support of their claims and their damages.
Counsel, real quick on that. Once we have the reconstructed record, is it your opinion that we will have an appropriate 18001 affidavit for all of the medical records presented?
What I can say is that the exhibits that were presented and listed in the pre-trial exhibit list included those affidavits. I know that they were removed before this went back to the jury, and I think as a result of the court reporter losing I don't want to say that the court reporter lost the exhibits disappeared. Intentional use of passive voice. Because the exhibits disappeared, I believe that that may be a question that we cannot answer, but we will certainly endeavor to do so.
Okay.
I have a question about the 40,000 in past medical. What do you think it should have been? And I'm not asking appellate, just in the real world, what do you, I couldn't find a number in closing argument that defense counsel gave. It said that, so.
Well, in this case, what we can do is we can say that we know that everything that was submitted to the jury was awarded. I actually believe that the jury, there was a Scrivener's error in the award. It said 69, and I believe the invoices, the bills all ended up 59.
Right.
We're not challenging the $10 extra. But it would have been I believe that the evidence that potentially could have supported the past medical award would have been the immediate chiro care, possibly. And there was one visit to a treating physician. I know that the cases say that you don't need an expert for example, transport and treatment at an ER after an accident. That type of immediate post-accident care, I believe, wouldn't require the expert testimony. So that's why we drew the line where we did.
So you draw the line sort of in time.
That
the
is
number of
certainly,
treatments, rather than the treatments were overpriced.
Well, and that's part of the challenge, with the 18001 affidavits, and why it's so important that trial courts don't improperly strike them, is because that kind of takes that out of the hands of the trial and puts it, makes the bills themselves presumptively sufficient. without, you know, the ability
Well,
to.
you could still attack it in trial.
You can still
I mean, what are you
argue
gonna
that the
do?
prices are not
What are you gonna do
reasonable.
if you retry this case? I'm just curious. You're gonna go back. It's a rear ender. I don't see how you can win on liability. You guys ran right into him. Jury's gonna fine for the plaintiff and give him something. So the question is like what? So what are you gonna ask him to award on the past medical?
Well,
Approximately, kind of a range.
I mean,
I'm not trying to tie you to it. I just want to get a feel for it.
I
Like,
certainly know that there were some large gaps in treatment and time, and so I think that that's going to be one of the issues that comes up again if this case is retried, is that there are big gaps in time, and that's an issue with regard to whether or not you can adequately tie that later treatment to the original accident that occurred years prior.
it could be worse. You never know what a jury will do.
I understand.
Thank
Thank
you.
you, Your Honor. Appreciate your.
Could I just, because I asked opposing counsel about it, ask you about the deposition, the use of the deposition, and the lack of an offer of proof? What's your response to that?
There were actually in the record that we cited in our brief 2 attempts to basically challenge the plaintiff's testimony at trial as being inconsistent with his prior sworn testimony, right? So we
But that's
briefed
impeachment.
both of those two, yes, both of those two attempts to impeach. I think what was most problematic in this case is the fact that the plaintiff was allowed to testify from the medical records and read from the medical records that were in English. And there was no objection raised there. And so when the attempt to impeach him with the deposition that was in English with a certified court translator present, who by the certification alone has proven capable of directly translating those documents. There's no concern of error there. This is one of those situations of fairness. You know, what's good for the goose is good for the gander kind of situation, I believe.
So I thought at trial it was argued that this was to refresh his memory, not to impeach him. Am I wrong on that?
Well, the way that it was written, one was to refresh his recollection, one, I believe, and I was just looking at what we cited in our brief, so I don't have the full transcript here, is that the first one was to refresh his recollection. The second one may have been leaning towards impeachment, and if I misspoke earlier, I apologize.
All right. Fair enough. Thank you so much.
Appreciate it. Thank you so much for your time, Aaron.
Thank you both for your arguments. We are going to take a brief recess, and then we will hear the next case on the docket. Thank you.
All right.